California has the most heavily regulated breaking lease framework in the entire country, consistent with the state's position as the most tenant-protective state in the nation. The governing law includes California Civil Code sections 1942 through 1954, the California Fair Employment and Housing Act, the Investigative Consumer Reporting Agencies Act, and dozens of local ordinances across the state. If you're a landlord or tenant in California, the breaking lease framework imposes extensive obligations on landlords, provides broad protections for tenants, and the consequences of non-compliance are severe. Let's start with the landlord's duty to mitigate damages. Under California Civil Code section 1951-2, when a tenant breaks a lease and vacates, the landlord has a clear statutory duty to make reasonable efforts to re-rent the unit. California's mitigation requirement is one of the most detailed and well-developed in the country, codified by statute and extensively interpreted by California courts. Section 1951.2 specifically provides that the landlord's damages for breach of a lease are limited to the worth at the time of judgment of the amount by which unpaid rent for the balance of the term exceeds the amount of rental loss the tenant proves could have been reasonably avoided. This statutory language places the burden of proving that the landlord failed to mitigate on the tenant, but California courts have interpreted the duty broadly and expect landlords to make genuine, documented re-rental efforts. The landlord must advertise, show the unit, and accept a qualified replacement tenant. The landlord cannot hold the departing tenant liable for the full remaining rent without making reasonable efforts. If the landlord fails to mitigate, the departing tenant's liability is substantially reduced. California's strong rental market, particularly in the coastal metros, means that landlords can typically re-rent quickly. In markets like San Francisco, Los Angeles, and San Diego, broken leases often result in minimal financial exposure for the departing tenant because re-rental happens within weeks. Early termination fees in California are governed by Civil Code Section 1671, which addresses liquidated damages. Under Section 1671, a liquidated damages provision in a residential lease is presumed invalid unless the party seeking to enforce it can establish that the amount is reasonable. This is the opposite of the rule in many states. In California, the tenant doesn't have to prove the fee is unreasonable. The landlord must prove it's reasonable. This presumption of invalidity makes aggressive early termination fees extremely risky in California. A fee that significantly exceeds the landlord's actual re-rental costs and expected vacancy period is unlikely to survive challenge. A fee of 1 to 2 months' rent may be defensible, but only if the landlord can demonstrate that the amount reflects a reasonable estimate of actual damages. In markets where re-rental happens in 2 weeks, even a 2-month fee may be challenged. Some California landlords avoid the liquidated damages issue entirely by not including an early termination fee, instead relying on the actual damages framework under Section 1951-2. Under this approach, the departing tenant owes actual damages, vacancy rent plus re-rental costs, subject to the mitigation duty. In strong markets, actual damages are often less than a 1-month fee. California's rent control and just cause eviction framework adds significant complexity. The Tenant Protection Act of 2019, AB 1482, imposes rent caps and just cause eviction requirements on most California residential properties. For rent-controlled units under AB 1482 or local rent control ordinances, such as those in San Francisco, Los Angeles, Oakland, Berkeley, and Santa Monica, the landlord's ability to increase rent when re-renting after a broken lease may be limited. Under AB 1482, vacancy decontrol allows landlords to reset the rent to market rate when a unit is voluntarily vacated, which includes a tenant breaking the lease. However, local rent control ordinances in some cities restrict vacancy, decontrol, or impose limitations. San Francisco, for example, has more restrictive rules than the state baseline. Landlords of rent-controlled units must understand how their specific rent control provisions interact with re-rental after a broken lease. Military members have the right to break a lease under the SCRA. California has an enormous military population. Naval Base, San Diego, the largest naval fleet concentration in the world. Marine Corps Base, Camp Pendleton. Marine Corps Air Station Miramar. Naval Air Weapons Station China Lake. Edwards Air Force Base. Vandenberg Space Force Base. Fort Irwin, the Presidio of Monterey, Travis Air Force Base, Beale Air Force Base, and numerous other installations generate massive military rental demand across the state. SCRA lease terminations are constant across California's military communities. Active duty service members with qualifying orders can terminate by providing written notice and a copy of the orders. The lease terminates 30 days after the next rent due date. No early termination fee or penalty applies. California also has state-level military protections under the California Military and Veterans Code that supplement the SCRA. San Diego landlords in particular process enormous volumes of SCRA terminations. The concentration of Navy and Marine Corps installations makes it one of the heaviest military rental markets in the country. California has enacted comprehensive protections for victims of domestic violence, sexual assault, stalking, human trafficking, and elder or dependent adult abuse that allow early lease termination. Under Civil Code, Section 1946.7, a tenant who is a victim of any of these offenses can terminate the lease by providing written notice and documentation to the landlord. The qualifying documentation can include a copy of a temporary or permanent restraining order, a police report, or documentation from a qualified third party, including a healthcare provider, domestic violence counselor, sexual assault counselor, or human trafficking caseworker. The tenant must provide at least 30 days written notice, or 14 days if the tenant is in immediate danger. When a victim terminates under Section 1946.7, the tenant is responsible for rent through the termination date, but is not liable for the remaining lease term. The landlord cannot charge an early termination fee. The security deposit must be returned within 21 days according to standard California rules. California's provision is one of the broadest in the country, covering domestic violence, sexual assault, stalking, human trafficking, and elder or dependent adult abuse. The inclusion of human trafficking and elder abuse reflects the comprehensiveness of California's tenant protection framework. The provision includes strong privacy protections. The landlord must keep all documentation confidential. The landlord cannot disclose the tenant's status. The landlord cannot use the termination as a basis for negative references or future denial. California also allows the victim to request lock changes, and the landlord must change the locks within 24 hours of the request. Tenants in California may break a lease if the landlord fails to maintain habitable conditions. California has one of the strongest implied warranties of habitability in the country, codified in Civil Code Section 1941 and reinforced by extensive case law dating back to the landmark Green v. Superior Court decision. The landlord has a duty to maintain the premises in a condition fit for habitation, including compliance with building and housing codes and maintenance of essential systems. If the landlord fails to maintain the property, the tenant has multiple remedies. Under Civil Code Section 1942, the tenant can repair and deduct, making necessary repairs and deducting the cost from rent up to 1 month's rent. The tenant can withhold rent under the common law remedy established by Green v. Superior Court, and the tenant can terminate the lease if the conditions are serious enough to constitute a substantial breach. California's habitability framework is enforced through multiple channels. Local building inspectors can inspect properties and order corrections. The California Department of Housing and Community Development oversees habitability standards, and tenants can pursue private causes of action for damages caused by uninhabitable conditions. California also recognizes constructive eviction. If the landlord's failure to maintain the property or affirmative actions render the unit uninhabitable, the tenant can treat the lease as terminated. California's natural disaster provisions are relevant to the breaking lease context. Under Civil Code Section 1942, if the premises are destroyed or made substantially uninhabitable by fire, earthquake, or other casualty not caused by the tenant may vacate and is not liable for further rent. California's earthquake, wildfire, and flood risks make this provision practically important. Tenants displaced by natural disasters have clear statutory grounds for lease termination. The devastating wildfires that have struck California in recent years, including fires in Sonoma County, Butte County, Los Angeles County, and throughout the state, have generated thousands of lease terminations. Landlords in fire-prone areas should maintain adequate insurance and have a disaster plan that addresses lease implications. California's Tenant Protection Act, AB 1482, also affects the breaking lease dynamic by limiting how much the rent can increase annually. Tenants in AB 1482, covered units who might otherwise have been priced out through rent increases, have less reason to break a lease. But when they do, the rent cap may limit the landlord's ability to charge a higher rent to the replacement tenant. From a practical standpoint, California has the largest rental market in the country, with more renters than any other state. Los Angeles is the largest rental market by total units. When a tenant breaks a lease in LA, re-rental depends heavily on the neighborhood and whether the unit is rent-controlled. Desirable areas, West Hollywood, Silver Lake, Venice, Santa Monica, Culver City, re-rent quickly, often within 2 to 3 weeks. More moderate areas take slightly longer. LA's Local Rent Stabilization Ordinance, the RSO, covers approximately 600,000 units and affects how landlords handle re-rental and pricing. San Francisco has an extremely tight market with extensive local rent control. Re-rental after a broken lease is typically very quick, but San Francisco's local rent control provisions may limit rent increases for replacement tenants in certain circumstances. San Diego's market is strong, driven by the military, biotech, tourism, and healthcare. Re-rental is typically quick. The enormous military population means SCRA terminations are constant. San Jose and the Silicon Valley corridor have strong tech-driven markets. Sacramento has experienced dramatic growth. The Inland Empire, Riverside, and San Bernardino has growing markets. Orange County, Santa Barbara, and Monterey have expensive coastal markets. Fresno, Bakersfield, and the Central Valley have more affordable markets with moderate demand. One critical best practice for California landlords: do not include an early termination fee without carefully evaluating whether it can survive challenge under Section 1671's presumption of invalidity. In many California markets, the actual damages approach under Section 1951.2, vacancy rent plus re-rental costs subject to mitigation, results in less liability for the departing tenant than a 1-month fee. Including a fee that you can't enforce creates a false sense of security and may invite litigation. Another best practice: begin re-rental efforts immediately and document every step. California's statutory mitigation duty under Section 1951.2 is clear and well developed. In the state's generally strong markets, prompt action typically results in quick re-rental. Document listing dates, advertising channels, showings, applications, and acceptance dates. A third best practice: understand how your rent control provisions, whether AB 1482 or local, interact with re-rental after a broken lease. If your unit is subject to rent control, know whether vacancy decontrol applies, whether you can reset to market rate, and what limitations exist. Getting the replacement rent wrong on a rent-controlled unit creates compliance issues that far exceed the cost of the vacancy. California limits the security deposit to 1 month's rent for unfurnished units and 2 months for furnished units. The deposit must be returned within 21 days of the tenant vacating, with an itemized statement and copies of receipts. Failure to comply can result in liability for up to twice the deposit in bad faith cases. These rules apply to broken leases and normal move-outs alike. For the complete guide to California breaking lease laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our Breaking Lease Law series.